As a majority caucus in Parliament, these matters have come to our attention, and we feel that there is a compelling need to state our position on the matters that are in public domain. We become aware that the Chief Justice has mooted a proposal to expand the Supreme Court to 20 judges for efficiency and effectiveness. Some people are saying that the Chief Justice does not have such a mandate to do so. We disagree and would say that per Article 1254 of the Constitution, there are some inherent powers provided for in this provision that allows the Chief Justice, as a Chief Executive and head of the Judiciary, to make such proposals. Quote, "The Chief Justice shall, subject to this Constitution, be head of the Judiciary and shall be responsible for the administration and supervision of the Judiciary." The question is, what constitutes administration and supervision? When somebody is in charge of the management of a body, he is able to determine how to run the place efficiently, what would make the work of that institution be properly done, and to make proposals within the context of the law. What does the law say on the composition of the Supreme Court? We may turn to Article 128 of the Constitution to give us a guide. 128.1 provides, "The Supreme Court shall consist of the Chief Justice and not less than 9 other justices of the Supreme Court." Now, the framers of our Constitution, in their wisdom, gave us a minimum ceiling. What did they anticipate? The anticipation was that there could be possibility in future to increase the number. That is why they did not provide for an upper ceiling. So if you read this and juxtapose it against the 125.4 that I earlier referred to, clearly you cannot argue that any increase in the number of judges at the Supreme Court above 10 is unconstitutional, or that the Chief Justice is wrong in making such a suggestion or proposal. Now, if you follow some of the discussions within the public domain, what the critics have failed to do is that they have not looked at the justification provided for in the analysis made by the Chief Justice. The Chief Justice did not just write a letter sitting on stilt. She justified it and made very compelling arguments. In fact, as per what we have become aware, the Ghana Bar Association was duly consulted, and the Bar Association, in principle, agreed to say. Other stakeholders also agreed to the need to expand our courts. But the argument which we in the majority caucus disagree with is the argument of timing. The timing. What is it about the timing? An institution like the Supreme Court, an institution like the Judiciary, with its constitutional mandate to deliver justice, is not bound by election timetable of the country. What these critics try to create, the impression they try to create, is that all that the Supreme Court does is to determine political cases. But I can tell you on good authority that the Supreme Court of Ghana the political cases that perhaps go there may not even be up to 2% of the cases that they deal with. Several cases go there. So the narrow path taken by these critics to create the impression that, oh, the timing is neither here nor there. In any event, to what use or to what benefit would it be to the president, Nana Addo Dankwa Akufo-Addo, to pack the court or do last minute appointments? In fact, of all the judges now in office at the Supreme Court, you have two who are not his appointees: Justice Bafo-Boni and Justice Gabriel Puaman. All other judges were appointed by His Excellency Nana Addo Dankwa Akufo-Addo. So, as astute politician as he is known to be, I do not think that he would want to trigger a debate in the public domain to poison the atmosphere. He will not do that. But a proposal of this nature to help with the justice delivery is to help us as a country.